So should we start?
बस अभी 1-2 मिनट और रुक जाते हैं, भी थोड़े से पार्टिसिपेंट और जुड़ जाएं। हम 1 मिनट बाद शुरू करते हैं गोयल साहब, 1-2 मिनट बाद।
कर देना चाहिए, लोग धीरे धीरे ज्वाइन करते रहेंगे।
ठीक है। गुड आफ्टरनून ऑल द पार्टिसिपेंट्स ऑन दिस टुडेज वेबिनार on a special topic, pre-pack insolvency resolution, introduced by the Insolvency and Bankruptcy Board of India, an arm of Ministry of Corporate Affairs. So welcome all the participants, and I also welcome our today's speaker, C. Anil Goel ji, the senior most insolvency professional in India and having the largest insolvency professional entity, AAA insolvency professional entity, and another moderator C. Ankit Goel ji, who is a registered valuer, having the largest registered valuer entity, partnering the largest valuation entity, AAA registered valuer entity. So इस कोरोना के पीरियड में लगभग पिछले 13 महीने से वी आर अंडर लॉकडाउन सिचुएशन। पिछले 6 महीने में थोड़ा सा नॉर्मल हुई थी सिचुएशन, उसके बावजूद हमें आज भी घर बैठ के काम करना पड़ रहा है और वी आर टेकिंग द बेनिफिट ऑफ दिस कोरोना टाइम। आल्दो कि हम काम नहीं कर बाहर नहीं जा सकते, अपनी सेफ्टी के लिए डर भी है, लेकिन उसके बावजूद भी एटलीस्ट नॉलेज शेयरिंग का स्कोप काफी बढ़ गया है ड्यू टू ऑनलाइन कनेक्टिविटी, एंड वी हैव कंडक्टेड मोर देन 100 webinars under the Chamber of Chartered Professionals, as it is a all India society having the members of chartered accountant, cost accountant, company secretaries, advocates, MBAs, and as well as other professionals are the members of this society. So everyone can become the member of the society by sending a mail to our email ID cpchamber2014@gmail.com. And being today's topic, अब थोड़ा सा मैं आपको आज के टॉपिक के बारे में भी बताऊं। प्री पैक्ड इंसॉल्वेंसी प्रोफेशनल एंड प्रोफेशन इंसॉल्वेंसी रेजोल्यूशन का पर्पज क्या है। बीइंग IBBI को इंट्रोड्यूस हुए तकरीबन 5 साल होने वाले हैं और 5 साल के अंदर काफी डेवलपमेंट हुई इंसॉल्वेंसी प्रोफेशन में। इट इज ए न्यू एक्ट फॉर इंडिया। सो डेली बेस पे कुछ ना कुछ अमेंडमेंट आ रही हैं ताकि लॉ स्टैग्नेंट हो सके। हर चीज के अमेंडमेंट के लिए NCLT और NCLAT के अलावा हर मैटर लगभग हाई कोर्ट या सुप्रीम कोर्ट में जा चुका है, जिससे कि कोर्ट के ऊपर भी क्लैरिटी हो चुकी कि क्या क्या होना चाहिए, क्या इंडियन गवर्नमेंट में सही चल रहा है, रिकवरी प्रोसेस के अंदर क्या इंप्रूवमेंट हो रही है। इवन ईज ऑफ डूइंग रैंकिंग के अंदर भी इंडिया की रैंकिंग 142 से 63 आ चुकी है, जिसके अंदर मेजर रोल IBC कोड का है। एंड नाउ IBC हैज इंट्रोड्यूस्ड प्री पैक इंसॉल्वेंसी टू सेव द टाइम, ताकि टाइम ज्यादा से ज्यादा बच सके और हमारी रेजोल्यूशन बहुत ही कम टाइम में हो सके, जिससे इंडस्ट्री भी चल सके, एम्प्लॉयमेंट भी बची रहे, रिकवरी भी हो सके। सो नाउ आई रिक्वेस्ट आवर मॉडरेटर मैं कथुरिया
So your voice broke in between.
एक मिनट मेरे यहाँ से आ रही है वॉइस?
बीच में 1 मिनट कटी थी।
Now I request Katuria, please introduce Anil Goel ji.
Namaste everyone. Namaste sir. So I'd like to take a minute to introduce Mr. Anil Goel, C. Anil Goel. He's a founder and chairman of AAA Insolvency Professionals LLP and non-executive chairman of AAA Valuation Professionals. Sorry. He's a co-chairman of ASSOCHAM National Council for Insolvency and Bankruptcy. He was a member of working group established by IBBI for implementation of individual bankruptcy and a member of SEBI group as constituted by IBBI. Being one of the most experienced IP professionals in the country, He is presently acting as a liquidator in 10 companies. He has been a regular speaker at various forums and webinars on insolvency and bankruptcy law, valuation and management of stressed assets under SURFICE. And today I welcome you, sir, for this topic today, the pre-packaged insolvency resolution process.
You're on
Mike,
mute.
sir.
You're on mute.
Yeah, thank you very much. So, first of all, my greetings to Vijay Kumar Gupta ji, and he's been always very, very enthusiastic about any new subject which comes. He has the knack of understanding the need of the professionals, and he always choose subjects which are most popular in that particular time. This kind of understanding that he has developed, this has benefited many professionals, and he always, whenever he requests us, whenever he asks us, it is always a pleasure to associate with the CA Vijay Kumar Gupta ji. And also his chambers of chartered professionals. Also, it's an all India society, which my understanding is it is without any other purpose. It is only for spreading education, and that is a very, very good objective, and it should be continued. Today, we would be discussing about pre-packaged insolvency resolution process, which was recently introduced by the central government on 4th of April by way of an ordinance. Later on, the Ministry of Corporate Affairs also issued rules and a notification where the amount of default was given as 10 lakhs. The IBBI also issued regulations on 9th of April 2021. So everything concluded within 5 days from 4th of April till 9th of
थोड़ा सा
April.
वॉइस को सर वॉइस थोड़ा सा इंक्रीज कीजिए प्लीज थोड़ा सा.
Okay.
Perfect.
So I think this is I'll just automatically, when the excitement comes, when people will start asking questions, the excitement also takes the volume up. So this is the introduction. Friends, today the format of the this discussions would be purely on question answers. I would request all of you to ask more and more questions. We also have prepared this webinar only as a question answer session. Ankit has done hard work on understanding the various questions. In fact, this may be our 10th webinar on PIRP, and we have been getting questions from various professionals and MSME corporate debtors and also bankers. And all those questions has been collated by Ankit Goel, and he would be asking me those questions, and we have somehow sorted them in a kind of way so that the what should come first and what should come later, and because see that actually would develop the understanding. It is not really good that I should start resolution plan questions before and admission later. So it has been accordingly arranged. In the meantime, Vijay Kumar Gupta ji will look at the question answer box, and he will also keep asking questions.
Yes, sir. Yes, sir.
To me. So otherwise, it would actually become a little boring. And in between also, I would also share my slides, because whatever questions will come, I will try to find out that particular slide, and I will also deliberate on that slide, because see, there are many people, they would like to see the slide and read also while they are listening. So this is the way that we would start the webinar today. So let us call it as a question answer session for the first time. So can we go ahead while I also share my screen, whether I'm
Yes,
I
sir,
have
yes, sir.
that permission? Yes, I'll do that.
Yes, sir. Yes, sir.
So good.
So your screen is visible, and I
Yes.
think my first question to you should be that what is the objective of introducing PIRP? What was the mindset of the government when they thought that PIRP should be, should be introduced in the Indian system of insolvency?
So Ankit, we have seen the in India so far, like we will only talk about MSME today, MSME corporate debtors. Why we are saying MSME corporate debtors? Because first of all, this PIRP is only applicable to MSME segment, and secondly, it is only applicable to corporate debtors, which includes private limited companies, and limited liability partnerships. So presently, there are four structures available in India for resolving financial stress of MSME corporate debtors. First is CIRP, which we all have seen for the last 4 years, more than 4 years. And then second is the arrangement under Section 230 of Companies Act, which is called a scheme of compromise or arrangement, where the corporate debt restructuring can also be planned besides the mergers, demergers, amalgamations. All this also can be planned under Section 230, 231, 232. There are other two which are out of court options. One is the RBI Prudential Framework, where this inter-creditors agreement is entered, and as per the circular dated 6th July 2019, that circular is still valid and it is applicable to MSME also, but it is only mandatory for those companies where the total outstanding is 1,500 crores and above. And fourth is very, very important, which is actually an informal structure, but which is most popular amongst the MSME corporate debtors. That fourth structure is the restructuring that we normally ask from our lenders, banks, and one-time settlement that we ask from our lenders. And that is where we, as a corporate debtor, we approach them. And although the banks do have their internal policies, some of the banks, they don't have their internal policies. And mostly our professional brothers would know that whenever we go for restructuring, the banks are putting conditions. Number one, that there is no process. Number two, there is no timeline. Number three, there is no compulsion to take decision within a particular framework. Number four, there is no judicial authentication. Number five, there is no Section 53 applicable. 53 applicable means like when the assets are less than the liabilities. So the liabilities which are in excess, those will get extinguished based on the priority which is set in Section 53. So that's what is that benefit is not available in that kind of restructuring or one-time settlements. Any MSME which has a good business model but somehow has landed into over-leveraged company or kind of more debt and unserviceable debt, those companies, in case they find a customer, the customer will not come and join that company because of the past liabilities, because of the higher kind of non-compliances, statutory liabilities. So in case the business can be sold, the businesses are not being sold only because of the past liabilities, because of the unclean slate, because of the hygiene of the company. So all these reasons were seen by the government, and then government proposed that the CIRP has limitations, scheme of compromise and arrangement has also limitations. RBI circular is not getting popular because of the rating, because of the no judicial authentication. So this was desired. So first in June 2020, the central government changed the definition of MSME so that more and more companies got covered under MSME, and later they actually introduced this PIRP. So the benefits of PIRP is Ankit. In fact, there are many benefits. In short, of course, during our discussions, most of the benefits will come, but I'm only just giving you the primary benefits of PIRP while we compare to the other options available with the MSME corporate debtor. One, that the MSME definition has been raised and it is applicable to kind of most of the companies having investment in plant and machinery up to 50 crores and turnover of 250 crores. this is the now new limits with effect from 1st of July 2020, and these limits cover many MSME corporate debtors. In pre-packaged insolvency resolution process, in short, we will call it PIRP, and the corporate insolvency resolution process that we have experienced for the last 4 years, 4 months, and that is CIRP. So as against CIRP, we would be using PIRP. So we will also be comparing with CIRP, this new structure, which is PIRP. In this PIRP process structure, the company remains in the possession, control, and custody of the promoters, directors. The directors are not suspended. The board of directors continues, and the responsibility to keep the company as a going concern doesn't shift to RP. The protection and preservation of the assets of the company doesn't shift to RP. It continues to be with the promoters, directors, and they run the company as they were running. It is just like as if a restructuring proposal has been submitted to the bank while the promoters are doing their own business. So this is not coercive, this is mutual. The promoters will apply, and the bankers will agree first before the application is filed to NCLT. So to my understanding, there will not be any opposition in NCLT, and there will not be any question of serving notice to other parties, because most of the stakeholders are already participating into the pre-PIRP process. The total process is 120 days. However, in case we also consider the process which is before this PIRP is, then it might even go to 240 days from today when we start preparing our base resolution plan, and when we finally get the approval. So it might take even 240 days. And moratorium is available in this also. The cost of this PIRP is much lesser than CIRP, and it is not disruptive. It doesn't disrupt business. It assures the continuity of business.
So other factors are like appointment of resolution professional and appointment of valuers. वो बाकी रूटीन केसेस में जैसे होता है वैसे ही चलेगा, या इसके अंदर बोर्ड ऑफ डायरेक्टर्स के पास पावर है तो वही चलाते रहेंगे?
No, board of directors will run the business. The RP would be appointed by the financial creditor, and RP will not have powers to run the business. Board of directors will run the business. The board of directors will continue to, however, the RP will only have a right to visit the company, ask them some kind of statement, some information, and the COC will have some power to limit their transactions. Like the COC can put a condition in the very first meeting that the promoters will not sell any asset. These are only illustrations that I'm giving. The promoters will not repay any loan. The promoters will not purchase any new assets. The promoters will not give any new loan to associate concerns. Any
like restricted transaction जो पहले define थी, I think वही वाली.
Absolutely. Those transactions will be defined before, and then the promoters will continue to run the business. However, in case the promoters find that there is a real situation, they can come back to COC, and the COC will approve that. So this is the kind of where is no disruption. The customers will not even come to know. The staff also may not come to know. So the company continues the way it is continuing, and in the meantime, PIRP is also going on. And this is basically where because what we have experienced in CIRP, that the promoters resist the CIRP. First of all, they don't allow the application to be accepted by NCLT, so they try to litigate, they try to pass time, and in that process of 1.5 years, which might be taken by NCLT, the company and the assets are minimized. See, the promoters get a kind of feeling that this company is not going to be staying with us, so they would like to take away whatever is possible. So, and especially in MSME corporate debtors, where those kind of systems are not installed, so the promoters can definitely do some kind of things where the assets can be diminished. And they also don't leave any amount in the company's balance sheet, in the company's books of account or banks. So the entire money is, no money is available with the company. Committee of creditor doesn't, they are not comfortable in participating and contributing CIRP cost. RPs are not getting fee, the professionals are not getting fee. So this kind of atmosphere in CIRP is not considered very healthy for resolution of the financial stress. So that rather is adding to the diminishing in the value of the business. The businesses are getting closed. The employment are actually, the employees are not working. They are not getting salaries. So the continuity is not assured in CIRP, whereas in PIRP it is assured. So Ankit, this reason this is introduced where the there is like I can further explain to you in case you are really interested, like what are the deficiencies in PIRP, CIRP. So that's not the question. I think you can move on to other questions.
So the basic idea then, I think to conclude what you said, the idea is one to create an incentive for the promoters to be part of the game, the part of the game that is to part of the possible resolution plan. Because the way I see it, a company goes into insolvency, the company has more debts to pay as compared to the assets that it has. And in case of an MSME entity, the promoter loses hope that he will never get it back, because even the creditors are of a perception that in case you give a haircut to the same person and give the person the company back to him. So in case some CD has 100 crores to pay to banks, and say he does not have 100 crores in the company, so and he only has say 50 crores, then in that case the bankers are shy to give that 50 crores that company and give a haircut of that 50 crores. But in case today in a PIRP process, there is now an option where the banker will have perhaps an option that it can look for a better plan. The promoter can give the best plan that it can based on the assets that are still remaining in the company. So I think that's what I understood from what you said. uh, Coming to the next question, like we understand that MSMEs are eligible to apply for PIRP, but going into more details, like who will apply? Like the company will apply, the promoters will apply. Maybe you can throw some more light on that. So who can apply for starting the PIRP process, and where is the application required to be made?
So at the eligible corporate debtors, first of all, it should be a company or LLP. Second condition is that it should be an MSME, and MSME registration is also required. The As we've already said, the I think we have another question which is regarding the details of MSME limits that we will come later, and then the default should be for an amount which is 10 lakhs or more. Now, this default doesn't mean that the company should be NPA. This default means that anywhere that you have defaulted, default can be with the operational creditors, default can be with the government authorities, default can be with the financial creditors. So any default, the company can move their intent to go for PIRP. Other conditions are that the company should not be under CIRP, the company should not be under liquidation, and the most
That means
important.
अगर हमारा टैक्स डिफॉल्ट है जिसमें हम अपील में गए हुए हैं या कोई डिमांड रेज हुई है तो उस केस के अंदर भी हम जा सकते हैं.
In case, Vijayji, in case we have filed an appeal, that is not something that we are accepting as a default. So in case we have not filed an appeal and that demand is considered to be crystallized and we don't have money to pay or we have not paid that, that is what is default. But in case we file an appeal, that means that it is not a crystallized demand.
Not accepted demand.
It is a protective, this is not even a protective demand, this is a contingent liability which may come to us in case we lose the appeal. The other thing that one has to see is the company should not be a willful defaulter, and the SEBI has not debarred this company for trading in securities, and the company, of course, the conviction of the offenses, that is also not applicable in this case. So these are something which are, Ankit, the basic eligibilities of any corporate debtor to go for PIRP. There is nothing else which is required. Of course, there are a lot of preparations that would be required. That is a separate issue. But your question ends here. My answer ends here as far as the eligibility is concerned.
All right. So the next question is that why will banks of financial creditors agree for the PIRP process to start? Because as I believe, the PIRP process requires them to give an initial approval on the base plan. So why will they be interested in cooperating with the CD or the promoter and say yes to a base plan?
So I somehow have just missed my PPT. I'll just do that. So Ankit, there are reasons for this. It all depends when this the.
सर इसको फुल स्क्रीन कर लीजिए, F5 दबा दीजिए,
I'll
F5.
do that. I'll do that. So the banks will definitely say the banks are definitely having some apprehensions. The banks are having some apprehensions, and they normally say that okay, it starts from the beginning. No, that's not I want. I can do just this way only. So in case Ankit, we try to see why the banks would agree. When we as a corporate debtor approach financial creditor that we need the restructuring and we would like to go through the PIRP model, the banks will say that why should I go for PIRP? So the reasons that we are going to give it to the banks is number one, that look, my company is having some defaults, and if I don't go for any kind of restructuring or any kind of resolution, then the default will go further deeper. Then somebody may start CIRP. Some of the creditor may file an application under section 7 or 9, or my business will close and the banks will go for SARFAESI action or any other action which would actually be. And in case of any statutory defaults, somebody might even take over the assets, attach the assets. So all these are the reasons that why I am coming to you, that this is the time that we should think about this restructuring. And I also have an investor who would invest some money, or these kind of various things that we might even tell bankers. Then we also tell bankers that in case we start PIRP, then you would not be required to make any provisions in your books of account. However, in the case of CIRP, whenever CIRP starts, banks are required to create provisions to the extent of 50% of the outstanding debt in case the CIRP starts of a company. Whereas for PIRP, no provisions would be required. And once this restructuring is approved, after that it will be considered as a restructured account, and all those income IRAC norms, prudential norms of RBI, that would be applicable as if this unit is a restructured unit. Then we only will tell the banker that this is a judicial process, this is a committee approach process, and also it's a consensual process. The litigation would be much lesser. If you would not accept my resolution plan, then you can reject it. So the company continues to be there. See, what are you losing? The banks are not losing anything, because the CIRP cost is also not to be met by them. The cost of this PIRP will have to be met by the company. And the RP is pretty safe, because the RP, because there is a provision that the company will deposit the fee and expenditures of the RP in a separate escrow account, and that escrow account will be operated by RP, so that the RP should have complete independence. RP will not have to beg for the fee from the same promoter against whom he is actually working for the transactions and all that. So the banks also will feel, because after some time the banks will have experience that this PIRP requires detailed information, even for filing application, even for filing base resolution plan. And otherwise banks normally they kind of struggle for various kind of information from the company, and the company doesn't provide at times. The banks also will be happy that they have now the real picture of the company, they have the picture of real assets and real liabilities of the company. In such cases, normally the banks have an experience that the debtors never the borrowers never cooperate for forensic audits. So in this case, even there is a case for pre-forensic audit, because when you file an application before NCLT, you also have to give a statement regarding the avoidance transactions. So the promoters would like to get a pre-forensic audit done, and in the pre-forensic audit, in case there is anything which is found, and accordingly the decisions can be taken how to circumvent those transactions, and that also the banks will be happy to take that information. So if the bank, this is not obligatory to the banks that they have to accept. Finally, they can say no. So the banks are not losing anything. Rather, they have better information. They can prepare themselves better. Otherwise, the banks also will feel comfortable that why should we agree with the base resolution plan? If we will not be comfortable with the base resolution plan, we will invite information from public at large. The public will also submit their resolution plans. Whosoever will offer us the best, he will take away the company. So that also is better for the banks. The valuation report also would be an information with the banks so that they are able to take the decision. Similarly, see, there is a competition. The competition would be there on a kind of a technology, which is a base resolution plan and best resolution plan will fight with each other. The banks will also be very happy that we are not supposed to monitor the business. Rather, we have the powers to limit the powers of the board of directors. RP will supervise only. RP will not take over. And in case there are some losses, in case there are some workmen whose salary and wages are supposed to be paid, that will be paid by the company itself. That will not come to us as a CIRP cost, and the RP will not ask us to contribute for the payment of salaries and wages. So they can, over a period of time, they would be wiser enough to introduce some kind of information flow from the company through RP to them. And all this is kind of considered to be all positive. And since the law has been structured in such a manner that the promoters will provide full information about the creditors, in case they don't provide any information about the creditors, they can be prosecuted. In case they conduct any transactions which are fraudulent transactions, that also can be plugged by COC. It can take certain decisions. No, the one question which Ankit is coming into the minds of the bankers, and they have been asking me, a scenario where the resolution plan of the promoters is not acceptable, and somebody from public comes and gives a better resolution plan, and the COC is inclined to pass that resolution plan instead of base resolution plan, then the COC will have an apprehension that once the promoters would know that we are not approving the resolution plan of promoters, then promoters will start doing fraudulent transactions and the assets will be diminished. So before they do that, the law provides that the COC can pass a resolution that the RP will take control and custody of the corporate debtor as RP takes in CIRP. So that is also possible by just one resolution, and NCLT will also pass an order so that RP gets all those powers which are normally given under CIRP. So that is also circumvented. The COC can also decide that our security guards would be deputed now, since we are not accepting the resolution plan of the promoters. The proposed RA, the prospective RA can also put their people so that no asset is taken out or no fraudulent transactions are done. RP can be asked to be a little more vigilant. So these are all the kind of precautions that can be taken so that all this is only to convince a bank that if you would start PIRP, that actually would be much better than doing nothing. CIRP, nobody likes. Scheme under section 230 is not very popular because every class of creditor will have to give 75% of their voting share. They have to give consent for the haircut or whatever is the proposal. And that is time consuming. That is also, of course, it is through the judicial structure, but every class of creditor will have to pass a resolution and approve the scheme and a scheme of compromise and arrangement. Banks are not comfortable in OTS because the bank feels that OTS is a lot of responsibility on them. The vigilance departments, they raise fingers on them. Other kind of restructuring, they are not bound to do that. And mostly you would see the banks would be doing only the conversion of some excess borrowings to working capital term loan, some kind of unpaid interest into funded interest term loan, some kind of LCs, devolved LCs, or invoked bank guarantees that can also be kind of considered as forced fund-based facilities, which can be again converted into a term loan. So these are the normal restructuring proposals which the bank normally accept, and hardly there is any scope for further additional money which can come. However, in PIRP, the promoter can bring an outsider. Promoter can give him 25%, 30%, 50%, 51% shares, and that money can come, and that will give comfort to the lenders, and the process will give comfort to the investor or partner. Why? Because the process would make this company completely hygiene company. It will be a clean slate. No Hydra head would be popping on the company every day after the resolution plan is approved, and the investor or the partner would feel comfortable in participating into the company. So these are the reasons why the banks will start, and banks would have no reason to say no. They would only negotiate about best resolution plan, and they will also try to find out the best resolution from public at large.
सर हमारे एक
Yes,
पार्टिसिपेंट
Ankit.
का इसके ऊपर एक क्वेश्चन आया है
Yes,
कि
please.
PIRP is basically restructuring the finance debt, and to MSME this must be a good advisory for starting again on a clean slate, and also to mitigate and overcome the contingent liabilities for government.
I think he's
So,
very, very intelligent person, and he has actually raised this. I wanted to touch this issue that the contingent liabilities are disturbing most of the MSME. Maybe some of the defaults that they have committed in the past, maybe because of some kind of non-compliances of the taxation, maybe some kind of raids, maybe some kind of investigations, maybe some kind of survey, and all these things may lead to huge demand notices or huge kind of tax assessments which are pending in the appeals. And always there is a sword hanging on the CD that any time the assets of the company can be attached by any kind of tax authority. So that scenario, in case we take to our financial creditors, they would definitely understand that, and we can actually structure a resolution plan which is very, very good for the survival of the company, where the operational creditors take little higher, a little bigger haircut, and the financial creditors take little lesser haircut, and those kind of resolution plans can be approved, and the company can find itself in a kind of easy spot, is a comfortable spot, and that hanging sword on the company can always be removed. This is a good question.
Another question, sir, do you think this PIRP cannot be used to avoid high liabilities of few operational creditors and government liabilities through judicial way, and after forfeiting these liabilities, debtors enjoy to free from heavy debt judicially?
I think it can be used that way. It can be used that way, and since the committee of creditor is only with the financial creditors, secured or unsecured, the operational creditors are not having any voting share. However, there is a scenario given in the code, in the regulations, that in case the operational creditors are getting haircut, then the promoters also should dilute their shareholding. Now, when they say that the promoters also should dilute their shareholding, that means that they should also have some outside investor. They should also have some outside partner. They should also lose some kind of control on the company. And if the operational creditors are losing money, then the promoters also should dilute their shareholding. They should also have another person who actually is putting some money and also putting some wisdom in the company, so that in future this kind of mistake should not be repeated by the so this is the condition although there is a relaxation to the COC also, that the COC can accept a resolution plan where the haircut is given to operational creditors, including statutory liabilities, but that the COC can record reasons that why they still feel that the promoters can continue with the project with the 100% of their equity because of the following reasons. But more safer would be whenever the MSME business is viable, there is no requirement of phoenixing, there is no requirement of starting a new company. Rather, it would be preferred now that the same company should actually get a clean slate after doing PIRP. The partner should be inducted, investor should be inducted, and the past liabilities, contingent liabilities be waived. Yeah, this can be used as Vijayji, the question is being asked, but there are some kind of checks which are built in the structure, and that is the promoters might have to dilute their shareholding and might have to sell or bring another investor or another partner.
My question is this is available only to financial creditor? I think it is already answered that it is available to corporate debtor only, I think.
This application can only be filed by the corporate debtor. It cannot be filed by the operational creditors or financial creditors. It only can be filed by the corporate debtor.
Scope of IP will be increasing or decreasing from this PIRP scenario?
The litigation would be decreasing, and see the way this PIRP has been structured, the promoters are having consent of going through it, the financial creditors are having consent. Who will oppose? Nobody would be opposing it, because the base resolution plan will never get public till the time the invitation is invited from the public. So the base resolution plan is a completely secret document. Whatever is mentioned in the base resolution plan, that will not come to the knowledge of statutory authorities or operational creditors, so they would never be able to come and put their hurdles in the NCLT or put their objections. So when the application is filed by the corporate debtor, there is no issue of issuing notices to the corporate debtor, which takes 3, 4, 5 months nowadays. And the financial creditors have also given consent, so they will also not have any objection. So this application, as mentioned in the code, that it has to be accepted by the NCLT within 14 days. And this might be possible in this case, although in CIRP also it was written that the application will be disposed of in 14 days, but that never happened. But in this case, it might happen because of no requirement of serving notice on the corporate debtor, because of all the stakeholders have already met and signed various documents already. So this would actually be considered to be a better proposition than CIRP. More and more people will come for this structure, because most of the practice of restructuring and one-time settlement would be routed through PIRP. Most of the mergers and acquisitions also would be routed through PIRP. Reason the promoters or the investors or the shareholders, the new partner, they will also always they would like that we would like to go through the PIRP rather than the normal amalgamation, merger or demerger. So I think the most of the transactions in MSME, that also would shift to PIRP. So these are the kind of opportunities available.
A question here from Ashok Agarwal ji. In this situation, whether the bank can ask for additional securities?
Yes, bank can negotiate with the promoters. Bank can ask for some additional contribution. Bank can ask for some upfront payment. Bank can also ask for some additional collateral security. Because see, try understanding the position of the bank. In case the bank says that, look, total outstanding is 100 crore and you are only offering us 50 crore, so we are reducing it by 50 crores. And we also understand that in case we go to liquidation, we will not get 50 crore, we will only get 20 crore. We have seen the valuation and we have also seen the kind of value of the company. But still, in case we reduce it from 100 to 50, it is not possible for us that we recover 50% from you in your personal capacity, because you have given the personal guarantee. So your personal guarantee is also getting waived to the extent of the haircut. Although the banks may also say that we would like to have a recompense clause. Recompense clause can also be negotiated by the banks, and the banks will say that once your company is out of red, once the net worth is positive, after that we would like to get this money, whatever we have lost in this PIRP, that we would like to get paid in 10 years in some few small installments. So those kind of clauses are also in practice for any restructuring proposals, and the banks may ask for that recompense clause. But then situation is this is what the banks will also prefer. The promoters will also prefer, and in case the promoters will not offer, then the banks, the financial creditors can ask the resolution plans from public. So there may be, because in this case, unlike in CIRP, lesser resolution plans are received in CIRP from public at large because of lack of information of the assets and liabilities and lack of information about the company. Since in this case the promoters are willingly coming, so they would provide the information. So if more and more information is available, then there is a possibility that some of the competitors may come and try to submit a resolution plan. So the promoters will also be under pressure to give best value to the bankers. So yes, bankers can ask and can negotiate.
Another question from Manju Mundra is simple question. What are the options available to operational creditors having default below 1 crore at present?
So this question is not PIRP question. For operational creditors, below 1 crore has got no option presently. They can only see in case they have taken some checks, fair enough, and they can go to 138 of Negotiable Instrument Act. So in case they have not taken any checks, then they can only go through the recovery process. I think the commercial
there is no option in IBC.
Yes. Currently, there is no option under IBC, and of course, once the capacity of the NCLT is revamped and it is upgraded, then government may start it again.
Ankit ji?
Yeah. I guess those were some questions that were coming in from the audience, and good that they're answered. So one question that comes to my mind, that is a frequently asked question, is that the PIRP process says that the resolution plan can be submitted by a third party, and that if that resolution plan is significantly better, then that plan will be adopted, and the plan that was proposed by the CD will not be accepted. So maybe you can throw some light on this part. What is the significantly better resolution plan? How will we see what is significantly better? Who will decide?
Ankit, this is a good question, and I have in this process I will have to explain three concepts. One is what is base resolution plan, and the other is what is significantly better resolution plan, and the third is what is best resolution plan, and then how all these will compete with each other. So the base resolution plan is something which will be submitted to the banks even before the banks agree for in principle approval of PIRP. This base resolution plan will be prepared by the promoters, directors, and they will provide all the information. They will provide their business plan. They would tell the financial creditors that this is the way that I would like to settle my dues. He may introduce a partner. He may introduce a shareholder. The CD may also ask for the haircut from financial creditors, haircut from operational creditors. All this, whatever a resolution plan can do under CIRP, the base resolution plan can also have all those things. The only thing that we have to additionally is that the certain confirmation that the company is MSME and the company has passed a board resolution. The company has also passed a special resolution of the shareholders. And the base resolution plan is conforming to all the requirements as mentioned under section 30 subsection 2 of the IBC. The base resolution plan is submitted first by the promoters to the banks. Then the banks agree for, in principle, agree to start PIRP. And once the PIRP is started with an order of NCLT, then the RP is appointed as appointed by the financial creditors. Then the RP would be given the same base resolution plans by the directors, and the RP will work on that base resolution plan. And we'll start constituting COC, and we'll start discussing that resolution plan in the meetings of committee of creditors. Now the COC after constitution may accept the base resolution plan in case there is no haircut proposed for any of the operational creditors, workmen, employees, government authorities, state government authorities, central government authorities, local authorities, tax authorities, statutory authorities, suppliers of goods and services. So all these, in case there is no haircut is proposed to any of these class of creditors, then the resolution plan can be approved by the committee of creditor without calling any fresh resolution plans from public at large. So this is the, and in the base resolution plan, in case the base resolution plan proposes any haircut to operational creditors, then the COC and the RP is obligatory to invite resolution plans from public at large. So even after this approval, even after the approval, if the COC rejects the base resolution plan, then the RP has to invite the resolution plans from the public. Now, what is significantly better resolution plan? It is provided in section 54K. The concept was, the discussion probably was that since the resolution plan is being given by the promoters will give always, they will start from the lowest possible figure, because in case they find that the company has a value of 100 crore, they will start with 10 crores and they will see how much public is offering, and thereafter they will improve because they will compete with the public, and finally they will take their own company in competition with the public. But the bankers definitely would never feel comfortable in case the promoters doesn't have any risk. So this significantly better resolution plan is, this concept is only created, this concept is inserted only to provide some kind of risk to promoters. See, first of all, there is a evaluation matrix. There would be a scoring system, and that would be also decided by the committee of creditors, like what would be the parameters of evaluation matrix, what would be the score system, what would be the weightage. So that will depend upon the size of the company, nature of the company, and assets of the company. Everything like depends upon, as in CIRP, the evaluation matrix changes from company to company depending upon various things. In this case also, the evaluation matrix will be there. The base resolution plan will be put to evaluation matrix, and for example, the base resolution plan achieves a score of 100. Now the COC will tell the promoter that in case we receive any resolution plan from public, in case we receive any resolution plan from public, which for example may have a score of 150 if put on the evaluation matrix, then we will not give you any opportunity to improve your base resolution plan, and we would be free to accept the resolution plan which is significantly better and it has come from public. Then we will not give you that right of first refusal. That would be that you will lose. This will actually put the promoters into kind of a risk, and they would offer their best at the first instance. So the base resolution plan should be closer to the market value of the company, it is an endeavor to kind of motivate to the promoters that they should give a resolution plan, uh, and that kind of resolution plan nobody should give from the public at large. So this is a concept of significantly better resolution plan. So in case there is any resolution plan which is received from public which is significantly better, so that resolution plan will be accepted by the committee of creditors without giving any opportunity to promoters to improve their resolution plan. Now, the third scenario is that the resolution plans are invited from public at large. There is no resolution plan which is significantly better. The COC negotiates with all the resolution plans which are received from public. All the resolution plans are put to evaluation matrix, and whichever is the best resolution plan in terms of the scores, whichever resolution plan achieves or best scores on that evaluation matrix, that resolution plan will be called best resolution plan. So the best resolution plan is based on it is one resolution plan out of the resolution plans which are submitted by the public at large. It is based on the evaluation matrix. It is also based on the negotiations which are done by the committee of creditors with all the resolution applicants, and whosoever is the best, that particular resolution plan will compete with the base resolution plan, which is called Swiss challenge. And that Swiss challenge can be on various parameters. For example, this committee of creditors can say that you can compete on upfront payment, you can compete on number of years the balance payment would be made, you can compete on the percentage of haircut, you can compete on anything that they can say. Then all these parameters would be fed into an Excel sheet or a technology which might even come. So then the best resolution plan and the base resolution plan will compete with each other. So finally, whichever resolution plan will get the highest score, that resolution plan will be put to vote. And even after that, the COC will have the power to reject or approve the resolution plan even after doing all this process. So this is the significance of the significantly better resolution plan, base resolution plan, and the best resolution plan. Ankit, if there is any follow-on question on this resolution plans for any kind of clarity, you can choose to ask now.
One question from Atul Grover. Some IPs feel that PIRP is a non-starter. What reason do you think of why PIRP is not going to be successful?
The RPs are feeling it's a non-starter because they, one, that they are feeling that the banks will not agree to start PIRP. Since I have spent about 10 minutes of today's talk, how we can convince and motivate banks to go through the PIRP process. Secondly, the banks will also start having kind of internal policies. RBI might also issue a kind of letter that the PIRP should be used for all kind of OTS or all kind of restructuring. So all this is possible to come forward. When even today, like whenever we are approaching, because we are handling some assignments of PIRP, so we are approaching the banks. Banks are only giving one answer, that we do not have any instructions from the head office. But this one thing which is very important is, like, once the base resolution plan is prepared and the company has done their own resolutions and everything, then the company has the power to convene a meeting of the creditors, and the creditors are likely to participate in that meeting. So once a process of meeting starts, once a process of then informing to the sanctioning authority starts, then gradually the banks will start understanding, and the banks will start taking up the cases of PIRP. Because there's nothing which the banks would lose in such cases. Nothing, no provisions are required to be made, no COC cost is required to be contributed. So no expense, rather they would get information about a client and they will take their own internal decision whether to handhold this client or they have to call back the loan. So that even can be used by the banks for seeking more and more information from the borrower. So it cannot be a non-starter, number one, because it is for MSME, and uh, I believe in case uh, the implementation of this is completely done and appropriately, and the NCLT passes orders uh, without waiting for months, then the government might even start for MSME partnership firms or MSME proprietorship concerns the same way. This is what is my feeling, rather than implementing the entire insolvency for everyone. But this might even be started for partnership firms and for the proprietorship firms, and that too restricted to MSME. So it cannot be non-starter, because we have seen various benefits as against corporate debt restructuring, uh, internal debt restructuring, OTS. So all these things will be routed through PIRP at least. Yes, please.
So I will, I understand you, and I of course get the point that there's a lot of reliance on the creditors to approve the plan, and of course there needs to be, everyone needs to play a role in the PIRP application to be made before NCLT.
Yeah.
But then there are rumors like on what is the limit, what should be the default amount. Is it 10 lakh rupee? Is it 1 crore rupee? Is there any limitation on the amount of default that can be taken to the NCLT? So maybe you can throw some light on that.
So one, that the limit of default, the amount of default is 10 lakhs in this case. So if the default is less than 10 lakhs of rupees, then this PIRP is not applicable. So there is no limit on the upper side. The default can be of any amount. The only thing which is required is that the unit should be MSME registered based on the definition, which is 50 crores and 250 crore turnover. So that's a very, very comfortable, because any company which is in financial stress, and also very important is that the definition of plant and machinery is very, very relaxed and practical. The MSME would use the definition of plant and machinery as the value given in the income tax returns. When we see income tax returns, it is only WDV which can be captured in the income tax returns. And in an RBI circular, it has also been clarified that the WDV of the would be only used for the ascertaining the value of plant and machinery. And even in the turnover, the export turnovers would be excluded. I believe in case any company which is having investment in plant and machinery which is higher than 50 crores, so in case they would try to analyze their assets, they would actually be able to exclude many assets, because as per the as per section 8, the pollution control, I mean, there are many assets which can be actually excluded, from the list of plant and machinery. I'll just show you the something which can be excluded. That's like the this is the pollution control, research and development, industrial safety devices, jigs, molds, fixtures, like interest during construction period, the transportation to the site. All this can be excluded while we are calculating the amount of 50 crores, and that to investment in the plant and machinery. However, the flip side of this is that even cars are included, buses are included, trucks are included, anything which is the plant and machinery, ships are included, vessels are included, aircrafts are included. These are all but the other thing is that this MSME, the trading companies cannot be MSME. Any company which is either manufacturing or providing any services can only be MSME. Like I was doing an analysis that even the real estate companies can be analyzed as MSME, because the real estate companies are also providing services.
Sir, what about the retailers, जो departmental stores and they are doing trading activities and the current definition? I think they are including the retailers.
No, the current definition does not include retailers. It is only for those businesses which are either manufacturing or providing any service. So the retailers are not included in MSME definition. So the calculation of turnover and the all this is explained well. One scenario, Ankit, can be discussed, and that is there any other question, Ankit?
No, you can go on, please.
Okay.
So I can take up another question once you're
So you
done
can
with
take up the question. You can take up the question.
So the next question that is a popular question is that that how is a PRP process affected by any pending section 7, 9 or 10 applications?
So this ordinance was promulgated on 4th of April 2021, and there are two scenarios. One, that as on that date, as on 4th of April 21, if there is any application of CIRPs pending, then the NCLT will dispose of those applications first, and then any application of PIRP will be taken up. Secondly, in case there is no application for CIRPs pending as on 4th of April 21, and the PIRP application is filed, after PIRP application is filed, the NCLT will not consider any CIRP application till the time the PIRP application is disposed of. Second scenario, in case any CIRP application is filed, and after filing within 14 days, if PIRP application is also filed, then also NCLT will give priority to PIRP and all CIRP applications would be kept in abeyance. However, in case no PIRP application is filed within 14 days, then the CIRP applications will get priority. So, and once this application is accepted, then of course no CIRP application can be submitted, because then it will be a moratorium. So
I got your point, and I think we can take some questions from the audience, from the participants at this stage.
How
okay,
code protects it?
Yes, please.
Ankit ji, Manindra Tiwari ji ka question is, sir, how code protects the right of operational creditors and government liabilities except dilution of shares? Because two another parties like debtors and creditors are deciding the fate of third parties.
So the code protects in the following manner. One, that the valuation of the assets of the corporate debtor will be taken by the RP and it will be considered by the committee of creditors. If the assets are more and the liabilities are lesser, then there is no possibility of any haircut to any operational creditors. So may I repeat, if the assets are more and the liabilities are lesser, then there is no possibility of any haircut to any operational creditors. Second scenario is that in the assets are lesser and the liabilities are more. In these cases, the fate of the operational creditor is the same. The operational creditors will not be getting anything because the company doesn't have asset, even if goes into CIRP or it goes into a SURFACE. So the operational creditors will not get any amount because the liquidation value of the company is much lower than the total liabilities. So this is the first protection. The valuers will value it, and if the valuation is high, it is not possible to give any haircut to operational creditors. But in case the valuation is lower, in case the assets are lower, then My understanding is that the operational creditor are going to lose money sooner the better, because today they might have an outstanding of 10 lakhs, and later because the company is already suffering losses, the outstanding might even go to 20 lakhs. And when the company will kind of raise hand or die, then the loss will be higher. So there is no other protection as we have seen in the CIRP, or we have seen in the PIRP is also the same thing. And the other protection which is used here is, which is also there in CIRP, that if the liquidation value is due to operational creditors, then the operational creditors will be paid first before any financial creditor is paid. That is also a protection to operational creditors. So my understanding is that most of the MSME, when they come to such kind of scenario, they would have lesser assets and more liabilities. So therefore, there is a likelihood that operational creditors will suffer loss. And this is the right question.
Another question, why any corporate debtor will go for PIRP, as it would decrease its credibility in the market. It may continue by managing in another way as it is.
Now, I'll just brief upon this thing. The apprehensions of the corporate debtor, why the corporate debtor should go to PIRP, and why not the other remedies. So the one scenario is that presently available, that the promoters will continue to run the company the way it is running, and they will continuously live in the financial stress, and they will wait till the time the financial stress goes deep and they are not able to, and the entire circulation of the money or the cycle of the business stops. This is one scenario, and this is mostly preferred by the companies till now. In case they find, in case they are having a good business model, but they are not able to settle their liabilities, then they go for one-time settlement whenever they get any customer for the company, or their some assets are being sold, then they go for one-time settlement. So the one-time settlement process is very tardy. The banks don't accept, the banks don't take the decision. So that process also can be run through PIRP. The other thing is, like, in case the PIRP is continuing, there is no risk of CIRP, and that's a moratorium. And in that moratorium, the company can do the business even better than before, because there is no pressure from the creditors. Then based on the liquidation value, the promoters will say that yes, we will get some waiver of the contingent liabilities, statutory liabilities, the defaults. So that also is possible under PIRP, which is not possible under any other remedy available. The promoters also, they would feel that this is a better way of diluting our shares in the company, or our profit sharing ratio in the company. And this is better way of inducting any partner, and they would have more and more possibilities of adding partners to such financially stressed MSME CDs. So practically, in case we see, there are many companies, they have positive EBITDA, and however, they are under financial stress because of the past losses, because of the high debt which they are not able to service. So through this PIRP, the debt can be brought to a level which is a serviceable level. In fact, we have experienced, like in various EPC companies or infrastructure companies, they are doing their businesses, their new contracts that they take in joint venture companies. Why they take in joint venture companies? Because see, they want to use their pre-qualification, but they don't want to have investment. And the new partner who is coming in that particular joint venture project, that partner is not comfortable in joining your existing company because of the liabilities. You would see that most of the infrastructure companies, whosoever are having turnover of less than 250 crore, will come under this PIRP. So those partners who are actually trying to do business with the company through joint ventures, they would come in this company through PIRP. So as somebody has rightly said that the disputed liabilities, contingent liabilities, disputes with the other partners, disputes with the directors, that can also be handled through PIRP. So the promoters have all the reasons to settle many things through PIRP. When I say many things, one, financial stress from the financial creditors, from unsecured financial creditors, even depositors, even some kind of statutory liabilities, the market liabilities, the loans that they've taken unsecured from the market. So all these difficulties can be settled through PIRP in case the liquidation value of the asset is small. This is the reason why the companies will opt for the PIRP and not CIRP.
Sir, one question from Shyamji. COC passes the resolution with stipulated voting percentage on different issues under CIRP, but PIRP regulation provides percentage of COC voting limited to appointment of resolution professional and passing of resolution plan, etc. Whether PIRP regulation stipulates any percentage of COC voting for imposing certain restrictions on corporate debtor.
Now
RP
see,
plan
like
के अलावा कोई और
whatever the provisions are, like when we say this new chapter, section 54, A to 54, and I believe these new sections are introduced, and these new sections are only for PIRP. But when we actually see, the entire code is applicable to PIRP, except for some clauses, some sections which are not applicable. So in case there is any appointment which is supposed to be done for the approval of the fee of the forensic auditors or approval of the fee of the valuers, all these are not those items where 66% voting share is required. So the COC will pass the resolutions with 51% of the voting share. So the same clauses of the CIRP, all those all the everything would be applicable to PIRP also. They accept one thing, that there is no IRP concept. It's a direct CIRP. So there is no requirement of appointment of RP, because the RP is appointed by the NCLT on the recommendations of the financial creditors. Then although you might not have read it in the ordinance, but the COC has the power to remove or change the RP. Those are also there, because the most other sections of code are applicable, most other. But in this case, the process is somewhat easier, because the claims are not invited from the creditors. The claims are the liability, the details of the liabilities, the details of the contingent liabilities are provided by the corporate debtor to RP. RP will send communication to each creditor and ask for their confirmation. In case the confirmation is not given, that also will be considered as confirmed. In case there is any objection, the reconciliation would be done. In case any other things, the RP will manage it, and finally the committee of creditors will be constituted based on the confirmation of the claim, and not by collation and not by verification. In the CIRP, we do collation of the claim. In the liquidation, we do verification of the claim. But in this PIRP, we are only doing confirmation of claims.
Ankit ji?
Yes, yes. So I'll move on to my next question now. So, like, of course, we understand that there's a process where the PIRP process can be initiated by going to NCLT. All the preparatory work will be done before that. The financial creditors will give a consent to the base plan. And under what circumstances can the PIRP fail? And what will be the repercussion of that failure on the promoter, on the CD, on the financial creditor? What will happen to them if the PIRP process fails?
So I think this is called a termination of PIRP. So the termination of the PIRP actually is in various manners. One, that if the resolution plan is rejected by the COC, then it will be considered as the PIRP fails, and the RP will file an application for termination of the PIRP. Secondly, as we have the provisions in CIRP, the COC will pass a resolution that the PIRP process may be terminated. Then also the RP will file the application to adjudicating authority for termination of the PIRP. Then the adjudicating authority will pass the order for termination of the PIRP, and also will decide what to do with the avoidance applications. In such cases, there are two more situations. The one is that there is a process which is called like the in between the PIRP process, the RP and the COC feels that the promoters are doing the fraudulent transactions. Then the COC immediately can pass a resolution that the RP should take over the control and custody, and that particular control and custody should be taken by the RP, and that particular application has to be approved by the NCLT. If NCLT approves that yes, the RP should take the control and custody, and thereafter no resolution plan is approved, then the company will go to liquidation, and this will not be called as a termination of the PIRP. And once the PIRP is terminated, it doesn't impact the continuity of the business. The company will continue under the management and control of the promoters, directors, board of directors, and there will not be any stigma on the company, except only one practical difficulty, that for any other PIRP, the company have to wait for 3 years. So once it is rejected, the new process cannot be started at least for 3 years. However, CIRP can be started, or however the other things are already open, because as everything is open to a company, after PIRP fails, everything else, whatever is available as a remedy, is available to that company. So this is what is termination of PIRP.
So is there a possibility of an alternative failure? Like this is one is termination. I think there's another process where if there is some fraudulent some fraudulent transaction or some fraud to be committed, or something not to be done properly by the promoters, even in that case the PIRP will fail, and in that case I think the repercussion is liquidation.
So that's I'm saying, like during the PIRP, in case the COC feels that there is a fraudulent transaction and they are not stopping it, then immediately they will say the RP to take control, and still they will invite resolution plans from the public. And in case that resolution plan from the public or from the promoters is nothing is accepted, the COC rejects all the resolution plans, then the company will not go back to promoters, then the company will go to liquidation. Okay. So this is the only, like there are two penalties, there are two kind of penalties which are built in for the promoters. Number one, that in case they give a very, very poor resolution plan, and then they will lose their right to maintain the company, to keep the company with them, and they will lose their right to upgrade their offer and compete in the process. Secondly, in case they do fraudulent transactions during PIRP, other than the applicability of section 67A and 77A, they would also lose the right to take the company back in case the resolution plan fails and the company goes into liquidation. And all their expenditures, and since this entire cost is borne by the committee, CD, the committee of creditors are not bearing any cost of the process. Neither they are not supposed to even bring the funds for the regular losses of the company. So this one process is called during PIRP, the entire business is taken over by the RP. Then there is another scenario which is there in section 54O, and that is the COC can also decide to convert PIRP into CIRP, maybe because they have found that the company is not MSME, maybe that they find that this company, the promoters has to be taken out of the process, and they also should be eligible for CIRP, means the default should be more than 1 crore. then the RP has to file an application to adjudicating authority, and the adjudicating authority will pass an order so that the PIRP gets converted into CIRP. And the RP should be appointed as IRP. And then the complete process of CIRP will start from the beginning. So this is also like in that case, all the avoidance transactions, all this, the CIRP shall also commence. So whatever time is lost in PIRP, that will be lost, and the fresh CIRP will start. So these are the circumstances where, rather than termination of the PIRP, the company can even go to CIRP, the company's management can be taken over, and in case there is no resolution plan approved, then the liquidation also can happen. So these are the other special circumstances where the PIRP can fail.
All right.
Yes, Ankit.
So there is the next question is that there is belief in the market, and there are some rumors that OCs cannot be given haircut in this PIRP process. So maybe you will like to clarify that what kind of haircut can be given to OCs, what circumstances can be given it under. Is there a possibility to pay everything to the financial creditor and not pay anything to the OCs? What are the rules?
Rather, I feel on the other side that since the COC is only with the financial creditors, the liquidation value would be assessed, and still they would like to, because they would be secured creditors mostly, and they would like to take the bigger cake, and they would not like to share any of the liquidation value with the operational creditors in case it is not really due under Section 53. Because since they are the COC, they would like to have a resolution plan which is acceptable to them and which gives them lesser losses. They would not bother about the operational creditors, and that is the reason that the operational creditors rather would actually be losing more money in PIRP, and more so the statutory authorities and all these contingent liabilities, and more of the MSMEs will come to PIRP because of these difficulties from the market, maybe from the suppliers, maybe from the unsecured lenders, maybe from the deposit holders, and all these liabilities they would like to get settled through PIRP. So it is in fact today also, like a couple of people, they asked me a question whether it is possible to provide for a haircut in a base resolution plan. I said yes. And the only thing is that in case you provide for haircut in base resolution plan, then the RP and the COC will invite resolution plans from the public, and you will have to compete with them. That's the only difference. But in case you don't provide any loss, the committee of creditors can still say we will still invite the resolution plans from the public at large, even if no loss is proposed to operational creditors, because they may say that we will get the best offer from the market. Why should we only get the haircut? We can actually get better value from the market. So they can decide about this. So this is a rumor that the operational creditors will cannot be given any haircut. Yes,
So is there a provision that there has to be some compulsory dilution in case the creditors are required to be given a haircut? Because if that is not the case, then maybe in a PIRP process, the promoter may say that, okay, my shareholding will remain as it is, the bank's debt will be remaining as it is, and the operational creditors will be nil. So in that case, all the loss will be OCs. So the promoter will still come out unscarred.
You are right, Ankit. The law provides that the committee of creditor will insist that in case you are proposing loss to operational creditors or loss to financial creditors, then you should also dilute your control and your control in the company. So when they say control in the company means shareholding or your profit sharing ratio, so they also have to dilute that. And what are the options when we actually say somebody that you dilute your shareholding in the company? So when we say dilute, that doesn't mean reduction. There are some people saying that so that means reduction, that in case today we have 50 crores of capital or maybe 10 crores of capital, and after PIRP we reduce it to 1 crore, by just reduction in the capital, would that be enough? No, I said no, it is not enough. Because see, presently when it is 10 crore, you are holding 100% as promoters. And when it becomes 1 crore, you are still holding 100%. It is only reduction in the capital. But where is the dilution in your control? So this is not the scenario. This is not called as the dilution in your control or dilution in your shareholding. It exactly means that today you have 10 crores of equity capital and you have 100% of the shares. Now, because of the losses, your capital, which is 10 crore, it might even get reduced to say 3 crores, and you invite somebody from the public who actually will invest 7 crores and will get 70% of the capital. So then one, that the money is coming to the company and that money can be paid to financial creditors or that can be used for revival of the company. And also your stake in the company is reduced from 100% to 30%, and a new management and the new shareholder have come. So it will be considered as if not only the creditors are suffering, it will be considered as if the promoters are also diluting their shareholding. They are also losing their ownership. So that may be a case of considering it that it is actually a genuine case that the promoters are also losing their control in this company. So it should be accepted. That is what is provided as dilution in the shareholding of the promoters, which is dilution by percentage and not by only value. Yes, Ankit.
So that's sorted out. So the promoter, if they are giving any haircut to financial creditors or OCs, then they need to they need to dilute their shareholding. So that's something that will prevent a promoter to make a profit out of a insolvency problem.
Yeah.
But then, like, there's a possibility, like, when a PIRP process is started, uh, and the plan, say, is not approved, uh, or the promoter's plan, I should say, or the CD's plan is not approved, and now the CD knows that no, there is some other competitive plan which will be now approved. So at that point in time, so PIRP is continuing, PIRP will continue, and maybe the plan that is approved is not the plan that the CD gave, because there is some significantly better plan that is out there. So in that case, how will the assets be protected by the bankers, by the financial creditors, by the resolution professionals? What powers do they have? Because the assets are in the custody of the CD.
So as I said, Ankit, like when these creditors start feeling that the resolution plan which are coming from the market is much better, and they are likely to approve that, they should immediately pass a resolution that the business may be taken over by the RP. And NCLT will also oblige in passing the fastest order so that the RP takes over the business of the company, the bank account of the company. All the employees will start reporting to RP, and the RP also can say that from now onward, the promoters will not come to the company and everyone will report to him. So this is the way that in CIRP also the assets are protected by COC and RP. Similarly, the assets would be protected by the COC and the RP, and also by way of deputing their own security guards, also by way of deputing any persons from the RA, so that there is no litigation later on. The RA can also say that this is only for inspection purposes. The videography can be made, then the inventories can be taken, because all this is otherwise also possible, because the information is already given. Valuation has already been done. All the up-to-date balance sheet is already given. The notice to creditors have already gone. So the assets and liabilities are completely with the RP and the committee of creditors. It will be very difficult for the promoters, because what we see in CIRP is only because the promoters have not shared with the detail of assets, the detail of liabilities, the books of account, all kinds of bank account, they have never shared. So in this case, they start with sharing only. So once every information is shared, and later on, if any asset is missing, then of course the section 67A and section 77A would be invoked, and that promoters actually will be fearing from those sections. So I don't think the promoters will have any option to largely take away the assets or cause any losses to the company or enter into fraudulent transactions. That would not happen. So once the COC can take two kind of decisions. Once that they can ask the RP to take the control. Secondly, when they sense that the resolution plan from the promoters would not be accepted, then the COC can put further conditions. The COC will say that no payment or no material would go out of the factory till the time it is approved by the RP or and COC. So that also can be submitted. Like the COC can always change their stand. Like first time when they were cordial with the promoters and they were asking the promoters their resolution plan, they only put some kind of limits. And later on, then when they felt that the market is offering much better and the promoters may not take their company back, so then they can even impose further sanctions, further limits, further approval requirement. So that is the way that we can protect the assets also when the promoters are thinking that the company is going away from their hands. Then also we can protect the assets. Yes, Ankit.
So when a CD, when a company is proposing to go into PIRP, file an application before NCLT, you have answered as to what all they will be required to file before NCLT. Any other preparation that they need to do? Of course, they will be collecting all the documents that you just mentioned. They will be, of course, getting the base plan to be approved by the financial creditors. What else do they need to prepare for?
See, one, that this preliminary information memorandum is also supposed to be prepared by the CD. Base resolution plan is supposed to be prepared by the CD. When it comes to the preliminary information memorandum, that also will have the information as we have in the information memorandum during in CIRP, the details of litigation, details of employees, and details of workmen, all statutory liabilities outstanding, all creditors, debtors, advances, everything is there in the and also the list of assets. So these are the total updation about the company, which should not be older than 14 days and before when you file the application. So all these lists will be submitted along with the invoices, along with their like even the operational creditors are also supposed to be supported by the invoices outstanding and the ledger accounts. So all this is the bigger calculation, bigger preparation, very big preparation by the corporate debtor before it goes into the PIRP. And most important is the projections, how they are going to revive the business, how the funds are going to be inducted, how this, if there is any additional funds required from the banks, whether the bank would give additional funding or not. That also is a very, very big question, which I think the banks may not give. Bank will say, okay, you bring your own partner, you dilute your shareholding. We are not going to give you any additional money, but they would actually facilitate the process that you are coming for. And they may give additional money also. They can give money, they can give additional funds also in case they have proper security, and the promoters are even offering additional security. The banks can also give additional funding. That's something which is possible, and nobody restricts them to pay additional money, give additional money during this process. Yes, Ankit.
So, what are the factors that an RP should consider? Because I think in this case, of course, the fee is required to be decided and approved by the creditors. Of course, the money also needs to be cordoned off into a separate account, and the fees of the RP as well as the professional expenditure expected to be incurred on the insolvency PIRP process is required to be put into a separate account. But the question is that what should the RP consider when he's deciding the fee, or he's trying to estimate the fee that he should get for this assignment?
So, Ankit, there are four situations in a PIRP. One situation is that somebody will have to be a consultant to the corporate debtor for preparation of all these documents, including base resolution plan, including strategy, including anyone who has understanding of how the restructuring can be done, anyone who actually can prepare a business plan for the future while this debt can be brought down to a serviceable level. The excess borrowings can be converted into any kind of term loans. So all this requires a consultant who has the experience and knowledge about the restructuring as well as PIRP. So anyone who actually would understand that this kind of resolution plan would be acceptable under PIRP, he should make it, and also the person who has a restructuring experience of preparing business plan, he should prepare. So this is a role where the person is giving consultancy to corporate debtor, preparing this resolution plan, also preparing very many other documents like list of assets, list of liabilities, detail of creditors with all the other information which is required, preliminary information memorandum, all that has to be prepared, and that's what is the job, and then continue with the corporate data during the entire PIRP as a consultant. When the banks will have first few meetings, that consultant would be instrumental in convincing the banks that yes, this proposal is viable and you should consider it, and he would be only a person who would be answering the questions of banks. Then the second stage is once the banks agree for in principle starting of PIRP, the banks will appoint an RP. At that stage, the RP has a pre-PIRP role. So the first stage I've already told you, that's a consultancy role, and that consultancy role should be different than the RP's role. Now RP role starts when the banks appoint him, and because then he has to do something which is a pre-PIRP role. He has to prepare a detailed report as per the format. He also has to appoint authorized representative in case there is any class of creditor. He will estimate all expenditure, he will estimate all the fees, and he will provide it to the COC, and COC will ask the corporate debtor to open a separate account under the signatures of the proposed RP, and that money should be deposited in that account. So that when the money, then the RP is supposed to take the fee, or it has to pay to the professionals appointed. That actually should be within the powers of the RP, and the RP should not go back to the management for even getting the checks for him for his own use or for his own fee or for the other professionals. So this is where the banks are supposed to, the separate account is supposed to be maintained. So in PIRP assignment, there will not be any risk of losing the or getting delayed payment or not getting the payment of your fee. So the second fee would be for the once the NCLT passes the order of PIRP. After that, the RP's role is to be RP for 120 days, and if the litigation continues with if the application is pending with the NCLT, then the role of RP will continue even beyond 120 days. Although presently 120 days has been calculated where it is inclusive of 30 days, which has been considered for the which has been taken for the NCLT to take a decision on the resolution plan. However, the fee of the RP in the first phase, which is a pre-PIRP stage where he has to do certain things and he will charge a fee. Then the fee for the PIRP, RP for the PIRP, then that is for 4 months, or that may be even 5-6 months. That should be per month fee. So there is another scenario in case the COC asks the RP to take control and custody of the assets, then the RP may even quote different fee in case he will have to take over the control and custody, then the fee would be higher, and that would be this much. So these are the 4 stages that the fee has to be earned from the corporate debtor. When this RP's role comes, RP will have to do the confirmation of the claims, preparation of the information memorandum, preparation of the bid evaluation or evaluation matrix, then also dealing with all the claims, reconciling with their with the approaching claimants, then the invitation for resolution plan, the document has to be made, then all the conduction of meetings of the COC minutes, then examination of resolution plans, presenting all the resolution plans, and all kind of voting. These are all the roles of the RP during PIRP. So accordingly, you should charge the fee. Normally, there are 3 or 4 parameters that we use before we quote First is the number of amount of debt, because as the debt would be higher, the sensitivity would increase. Number two, the number of locations of the assets and businesses of the company. Number three, the kind of litigation details. Number four, the number of the COC members, because more the member, more efforts are required. The number of workmen, and the most important is whether the company is having running operations or not, and if yes, at how many locations. So these are all the factors that we decide before we discuss before the fee is quoted for any case. Similarly, in this case also, the fee has to be quoted based on this only. Yes, Ankit.
The next question is that, like, of course, we have seen how CARP process has involved a lot of litigation, and that litigation happens at times from the resolution applicant, at times it happens from the CD, from the workers, from the creditors. It can be a lot of people who do the litigation in the courts to preserve their interest in the CIRP process. So in CIRP process also, I guess there will be some litigation. So what, in your opinion, will be the possible litigation that will happen in PIRP process? And what are the powers that even the code talks about when it talks about preserving the rights of certain participants of the PIRP process, and who can appeal, who can who will possibly litigate, and what will be the objective of that litigation?
So at the time of first is at the time of uh, this application for admission of PIRP. The application for admission of PIRP, I don't think it would be uh, kind of litigation would not be seen, because there will not be any person who actually would be opposing this application in the court, except in some cases where the 34% bank financial creditors who have not voted, they might even say that the process which was conducted, which is pre-PIR process, was not right, and it was fraudulent, and these resolutions are actually passed without our information, without our knowledge. That is the only one possibility. Although section 19.2 is also there for seeking information from the promoters, but that section 19.2, in case that would be there, then the COC can definitely threat that then we are not going to accept your resolution plan in case you are not providing information. So rather than going to court, it will only be handled in a COC meeting, that unless you provide this information, we will not accept your resolution plan. So the 19.2 litigation also would be reduced. The litigation that is normally seen in the taking control and custody, that also would not be there, because the control and custody is not required. Any kind of tenancy, whatever it is, that has to continue, so that is not required. So the litigation on account of operational issues would not be required, because that of course will continue, as the company is already moving under the control and management of the board of directors. So that would continue. So that litigation is not required. So the only thing is that once the resolution plan is approved, and then there is a higher cut to operational creditors and lower cut to financial creditors, some of the operational creditors might even say that this entire process of PIRP was a sham process, and there was only one financial creditor, and he has not given any haircut. He has not been given any haircut, and he has approved a resolution plan, whereas the entire haircut has been given to operational creditors. And this one particular financial creditor who has a financial limits of only 2 crores, and he has actually given the haircut which is 100 crores, and all that to the operational creditors. So those kind of litigation may come, that it was entirely a sham process. The company was not under this stress, but then of course the law provides that if there is a shortage of assets as against the liabilities, section 53 would prevail, and whatever may be the reason, the resolution plan would be accepted in case there is a default, and in case it is approved by the committee of creditors. So the litigation would be much lesser.
So maybe we can take some questions from the participants.
The questions are, when we are inviting another plan, how to identify the resolution applicant?
So there is a process of public notice for invitation of resolution plans as we have it in, but like that is how that public notice would be given, that will be decided by the committee, and mostly the committee will decide that you should put it into the economics times, because they are not spending the money is being spent by the company. Like when we in CIRP, we try to do some take an approval of the expenditure for invitation of the Form G, and they will say, okay, you find something which is the lowest cost. Now, in this case, they will ask that the multiple releases should be given in the economics time, so that we get the best options from the public, because the expenditures are being borne by the company and it is not being borne by the creditors. So this is the one scenario, that the one that the invitation for resolution plans will be on the on the website of the corporate debtor. It will be also on the website of the IBBI, and also the way the COC would decide, that is the way the invitation would be made for seeking resolution plans from the public. And there will be a document called IFRP, which is invitation for resolution plan, and that IFRP will be just like RFRP in CIRP. All the information would be there regarding the process in IFRP.
Kindly explain the definition of default.
Now, the definition of default is the same as we have in CIRP. Let's take an example of operational creditor, somebody who have supplied the goods to us, and we had given a purchase order that we will give you payment within 60 days, and we have not been able to give payment to him after 60 days of the receipt of goods. Then there will be considered as a default. On 61st day, it will be considered as a default. So in case of any installments, in case some installments are not paid, and if the total of these installments is now 10 lakhs and more, that also would be considered as default. In the case of working capital facility, in case my amount is overdrawn as against my drawing power, and that will be a default. And I'm not able to clear that default. So that default, this is the only definition of default. The amount which is supposed to be paid is not being paid on that date. So there is no times that the default should continue for this much of time. That's not there.
What are the major issues are the professionals going to face in PIRP process, and what the best practice do you suggest?
The major difficulties would be to motivate the financial creditors to in principally accept the resolution plan. Gradually they would be educated. Presently they are not having any information. The banks will come up with their internal policies, and those policies will finally govern. The major difficulties would be only to finally get an approval of the resolution plan. And after the resolution plan is approved, and the major difficulty for the professionals is that this is a time-bound process, and once you are appointed by the financial creditors and the application is submitted to NCLT, you have to work right from that day. You cannot wait till the time the PIRP order is passed, because once the PIRP order is passed, within the first 15 days, you have to do a lot of work. And that lot of work that has to be done when you are appointed and you have submitted your report and the application is submitted to NCLT, let NCLT take 14 days or 1 month or 2 months. And that should be the time when you actually have to prepare everything that you need. And otherwise you will not get the time to do the transactions in this timeline manner. Within 2-3 days, you have to just send a communication to all the creditors. Then all the creditors will come and they would confirm their claims. All this can be done officially, unofficially by the corporate debtor before even the PIRP starts. So this will be a lot of work, and the work is in fact more intense because in most of the CIRPs, when there is no information with the RP has nothing to do. But in this case, when the RP has most of the information, then the RP has to process that information and put it in a direct right perspective in the IFRP or in the bid evaluation or in the claim verification, list of creditors, list of assets, list of liabilities, list of litigations, list of employees, list of workmen, everything has to be done properly and completely authenticated, because if the promoters are also providing this information, they also have to authenticate it. So these are the biggest challenges that actually the professionals will feel. And also this is a case where the market has to be developed by the professionals. In case the market would not be educated, it will not work. See what has happened in the personal insolvency scenario. In personal insolvency, one, that there is a case which is the people are awaiting for the Supreme Court judgment in the case of Anil Ambani. Once that order comes and once the complete adjudication of the entire process is done by the Supreme Court, even thereafter, I haven't seen that the corporate guarantors are coming forward for the insolvency. The country is not, this is the only reason is that they have not been educated. Nobody have told them that you would be having complete discharge within 1 year. Whatever may be the reason that you would be discharged, whether your assets are sold or not, whether your bankruptcy is closed or not, you will get the discharge within 1 year. And then thereafter, you will be able to start your business again. You will be able to have your house in your name, your car in your name. That is not actually been spread around to the actual users. See, the difficulty that we all are facing is whatever we do it amongst our own professional brethren. And today also, in case it is a chartered accountancy, chamber of chartered professionals, so that means that it is for professionals. How do we reach out to the corporate debtors? How do we reach out to the those personal grunters who are suffering? They are not even able to start any business because their grunty matter will continue for 15 years. It is only because most of us as professionals, whenever we deal with any entrepreneur, we should have this information, we should have this knowledge, and we should prepare him that this is the right way of doing the things. So educating the MSME corporate debtors is the bigger hurdle. Then only they will come forward. Otherwise, they might even fear that my company may go to liquidation. I'm okay, the way I'm running it is okay. I will continue the way business is running. Why should I disrupt it? So those kind of apprehensions, because people have seen in Bush and Brothers, people have seen other cases where the promoters are out and all kind of litigations are going on, all kind of offenses are being imposed against them. So those kind of things are actually creating some fear as against PIRP also. But these are the challenges that I feel that the one is the challenge with the professionals because of too much of work and too less timeline. Second, to motivate a corporate debtor to go for PIRP. Third, to motivate the bankers to agree in principle. These are the challenges that I feel. It was a good question. Thank you.
Another question. Can a corporate debtor give a resolution plan in such a way that his another company will purchase the defaulting company?
Yes, it can be given.
Even if it is a related
but that can be given when the public invitation is made. When the public invitation is given for inviting resolution plans, then anyone can give, any related party can give, even one director who is competing with the existing directors, he can give. One breakaway director can also say that I want to take away the company. Two fighting directors, they can give resolution plans, independent resolution plans.
सर क्या कोई अभी तक कोई PIRP की एप्लीकेशन फाइल हुई है? बीइंग कोरोना भी आ चुका है और एप्लीकेशन आई भी, रेगुलेशन आई भी टाइम नहीं हुआ है, अभी 4 अप्रैल को आया है.
No,
so
we are preparing some base resolution plans, but the only difficulty is that the bank's saying that we don't have any instructions. We have to have internal instruction, then only we will participate.
Actually, resolutions नया amendment है तो head office पहुंचने में फिर से नीचे तक आने में टाइम तो लगेगा ही.
टाइम तो लगेगा. Yes, time to लगेगा.
Ankit ji?
So I think we're through with almost all the questions. We have also, I think Vijay ji has successfully taken and answered all the questions on the Q&A panel. And we are, I think some questions in the chat box are also there.
मैंने देखा नहीं इनको.
Chat box में Rupali ji is asking that is public notice required to be given?
Yes, public notice is required to be given for PIRP, but the public notice is not required to be given in newspaper. Public notice for start of PIRP is required to be given on the website, on the IBBI. However, the public notice for invitation to public resolution plan, that will be given with the directions of the COC. And as I said, that the COC will ask for economics times because they are not spending the money.
So Ranjan Chakra is asking that if the IP involves himself in the preparation of base resolution plan, will he kind of put himself into a conflict in case in future he is the proposed RP for the PARP process or for the CRP process or the liquidation process?
One scenario is that the conflict as per the eligibility of IP to be appointed as RP. Now, in case we exactly go by the definition says that you should not be the auditor, you should not be the cost auditor, you should not be the secretarial auditor, you should be a person who can be appointed as an independent director on the company. These are the eligibilities. And the last is that you should not be a consultant to the corporate debtor earning more than 5% of your revenue from them. So these are the conditions of the insolvency professional who can be appointed as the RP. So these conditions can be definitely, because see, one, that in case I am not an auditor, but I can definitely be a consultant. Once I am a consultant for preparation of base resolution plan, that means that I am also holding the meetings with the, if I am not holding the meetings with the financial creditors, but I believe that anyone who is traveling, who is actually having the meetings from the side of the promoters, the bankers will never appoint him. Even if that particular insolvency professional is eligible to be appointed as RP based on these conditions that I said just now, but the bankers will not appoint the same person as RP because the bankers would like an independent person, a person who has not been working with the promoters in the past. That is what is my feeling. And why should they appoint the same person who is working for the corporate debtor?
एक क्वेश्चन है, how many MSMEs are eligible for PIRP, as many of them might be other than corporates. So I think only corporate MSMEs are allowed in PIRP.
Yeah, only corporate MSMEs.
Ankit ji?
So I believe we have taken most questions, Vijayji.
Yes,
If
yes.
there are any pending questions, we can ask
all the questions
participants to put in.
All the questions from chat box as well as Q&A link has been taken up.
And I think we managed to make it good time. It's 6:02. So
I think we also have finished most of it because see, I never wanted to go into the detailed process. The detailed process is written. They see the only concept that we wanted to have today is that it should be convincing to the professionals that we are having in our participants today. It should be convincing to the corporate debtors that what are the difficulties and what are the benefits. As far as the process is concerned, any person who will start making an application, he will find the process because the process is not that difficult. Why should we discuss process when we are actually spreading awareness? So we just missed the process. Everything else has been discussed.
So thanks, sir. And I request all the participants that don't worry about the contact details of C. Anil Goel ji and C. Ankit Goel ji. The complete details, mobile number and email ID will be shared with all the participants. So you are free to contact them freely. Being we are the founder of Chamber of Chartered Professionals. We are here to deliver the information, knowledge sharing with all the speakers available, with Chamber, with ICI, ICSI, ICMI. So we are taking the support of all the good speakers at this platform. And thanks, Goel sahab, for giving such detailed deliberation in a Q&A session link. So it is easy to understand. Even this chapter is new to me. So हमारा चैम्बर आपके लिए इन फ्यूचर भी इंसॉल्वेंसी एंड अदर टॉपिक्स के ऊपर प्रोग्राम करते रहेंगे एंड वी विल टेक द हेल्प ऑफ मिस्टर सी अंकित गोयल जी एंड सी अनिल गोयल जी. So thanks, Goel sahab.
Thank you, Vijay ji. Thank you very much.
Thank you, everyone.
Thanks to the Chamber of Chartered Professionals and thanks to all the participants. Trust me, most of the chartered accountants who are engaged in the traditional practice, I would simply say that it is a time to come out of the traditional practice and do something which is new. the new fields are more attractive rather than the traditional fields. Understanding and then thereafter reading is very, very important, and marketing is also very important. And please do marketing, spend some money on marketing and invest in marketing. That's what is the new kind of mantra for professional success. Thank you all. Thank you, Ankit, for
आपकी लाइन से एक
taking
लाइन
time.
अच्छी निकली कि इन्वेस्ट इन मार्केटिंग तो है, इन्वेस्ट इन योरसेल्फ. बीइंग लॉकडाउन के चक्कर में आप सब घर पे बैठे होंगे, तो उसको वेस्ट करने की जगह स्टडी पे लगाएं. जैसे अनिल गोयल जी और अंकित गोयल जी आर ऑलवेज एक्टिव, क्योंकि वेबिनार देने से पहले इसकी तैयारी करने में भी बहुत ज्यादा टाइम लगता है. कितने माइन्यूटली और बारीकी से एक एक पॉइंट्स के क्वेश्चंस निकाले, उसको उसके ऊपर सॉल्यूशन, और क्वेश्चन आपने कहीं से भी क्रिएट किया, बट सॉल्यूशन वाज अवेलेबल विद मिस्टर गोयल. So
no, it is
thanks again.
it's a wonderful experience, this lockdown, that we all are working from home, and whatever time that we save, that we are investing in study and creation of this kind of concepts. Thank you very much. So this is our way of learning, I always say. So we will keep learning the same way. Thank you. Thank you very much.
All right, everyone. Thank you so much. Thank you, Vijay ji. All right.